Helen, welcome. Today we're diving deep into two of the biggest data crises in recent memory, and we're going to explore a really critical legal distinction. What exactly is the difference between a cybersecurity failure and a systemic privacy failure? We'll be looking at two landmark cases that literally changed the game for corporate law and our digital rights.
So I want you to imagine this for a second. Let's say one company has its vault broken into by some really sophisticated thieves. Now imagine another company that just leaves its vault door wide open with a policy that basically lets anyone walk in and copy whatever they want. From a legal standpoint, these are two profoundly different situations, right? And that simple metaphor is the core of what we're talking about today: Equifax versus the Facebook Cambridge Analytica scandal. Here's how we're going to break it down. First, we'll define these two very different types of data crises. Then we'll put the incidents head-to-head and look at the wildly different penalties they faced. From there, we'll explore the new era of regulation they kicked off, and finally, we'll pull out the key lessons for all you legal professionals out there. Okay, let's start by laying down some legal groundwork. It is absolutely crucial to understand that not all incidents where data gets lost or misused are the same, legally or technically. The specific nature of the compromise is what dictates the entire legal response that follows.
A data breach, in that classic legal sense, really hinges on one key word: unauthorized. It means there was some kind of illicit intrusion. Someone bypassed security measures to get in from the outside. So think of this definition as our legal baseline. It frames the Equifax incident perfectly.
And this points to a major shift in legal thinking. For decades, corporate security was all about building a fortress. The legal and the technical framework used to focus almost entirely on stopping external attackers, hackers, from getting inside the walls. The idea of a huge failure coming from inside, from the company's own policies, well, that was way less of a concern. Okay, so now let's apply this distinction to our two big cases. What we're really looking at is a tale of two fundamentally different kinds of failures. One was about cybersecurity, and the other, well, it was about data governance. This slide really just lays out the whole contrast. Equifax was a clear-cut case of cybersecurity negligence, plain and simple. Hackers got in by exploiting a known vulnerability that the company just hadn't bothered to patch. But Facebook? That was a failure of its own internal rules. The data was actually first accessed by an authorized developer, but it was then completely misused because the platform's policies were just so incredibly permissive. And when you look at this timeline, it just screams corporate liability. The vulnerability was known about in March, but for 76 days, from May to July, attackers had free rein, with unchecked access to some of the most sensitive personal data you can imagine. From a legal perspective, this long failure to patch the hole and then detect the intrusion is a textbook example of inadequate security diligence. And here's how the privacy failure worked. See, this wasn't a hack. In a way, it was a feature, not a bug. The problem was that Facebook's platform used to have policies that allowed for this incredibly invasive friends of friends data harvesting. The friends of the app's users never gave their consent, and that created this huge ethical and legal loophole that was exploited on a massive industrial scale. So given these two totally different kinds of failures, it's probably no surprise that the legal and financial consequences were also worlds apart. Let's take a look at the penalties each company had to pay. Equifax eventually reached a global settlement of at least $575 million with regulators like the U.S. Federal Trade Commission, or FTC, and the Consumer Financial Protection Bureau. Now, that's a huge sum, but the structure is what's really key here. It was focused on consumer restitution and credit monitoring, basically paying for the direct harm caused by the security breach. Now, compare that to Facebook. The FTC hit them with a record-shattering $5 billion fine. And this wasn't about restitution for a specific breach. No, this was a punitive measure. It was a punishment for systemic, long-term privacy violations that were baked right into the company's business model. I mean, this chart makes the difference just crystal clear, doesn't it? The fine against Facebook was nearly 10 times larger. So why? Well, it's because regulators saw their failure as something much deeper. It wasn't just a mistake. It was a matter of policy. The FTC was sending a clear message. If your business model is built on flimsy data governance, you're going to face astronomical consequences. But these cases didn't just end with fines. Not at all. They fundamentally changed the entire legal landscape for data protection and corporate compliance around the world. They really did spark a new era of regulation.
You can see this clear progression, this direct causal link between the scandals and real legal reform. First, public outrage exploded, creating immense political pressure. This led to aggressive investigations from regulators, which then exposed just how inadequate the existing laws were. And that directly fueled the push for powerful new frameworks, like Europe's GDPR, the General Data Protection Regulation, and new privacy laws in the US.
And this brings us to the new reality, where companies didn't used to have to worry about constant oversight. They are now used to operating in a totally different world. Rigorous regulatory scrutiny is the new normal, and the potential price for not complying has become, frankly, existential. So in the end, their legacies are distinct, but they're both incredibly important. Equifax forced a global reckoning on cybersecurity fundamentals, patching systems, having a response plan, and notifying people in a timely manner. Facebook, on the other hand, it forced a much more philosophical debate about privacy itself, making informed consent a central pillar of modern data law and platform accountability.
So what's the bottom line here? For those of you studying or practicing law, what does this all mean? How has the ground permanently shifted? Let's quickly wrap up the key takeaways.
I think this quote just captures the shift perfectly. The time when companies were not used to treating data governance as a top-level, C-suite responsibility, that time is gone. It's over. In today's legal environment, proactive, demonstrable compliance isn't just a nice-to-have, it's a fundamental requirement for mitigating corporate liability. So for your future practice, the most crucial takeaway is this. You have to be able to dissect the nature of any data incident. Is it a security failure? Or is it a privacy failure? That one answer will determine your entire legal strategy. It means auditing a company's privacy policies is now just as critical as checking its cybersecurity. And above all, understanding the legal nuances of consent is absolutely paramount.
And that brings us to our final thought. What these cases really highlight is a massive legal and ethical question that we're all still grappling with. We have corporations driven by profit, we have regulators who are often playing catch-up, and then we have individuals who may not have the time or the expertise to manage their own digital footprint. As future legal experts, figuring out where the lines of responsibility fall between these three groups, well, that's going to be one of the greatest challenges of your generation.